Immunity deal is the biggest scam against the taxpayer in American history. And Americans are going to pay taxes, and Trump and his clan won't. Career IRS attorneys wrote a 25-page memo preparing defenses against Trump's lawsuit, and they recommended DOJ move to have Trump's lawsuit dismissed. The IRS reportedly gave this memo to Treasury officials in April before the settlement. Did you see that memo?
There's continuing litigation, and I'm unable to answer.
Did you know in advance that Trump was going to file a suit against the IRS?
I did not.
All right, I've written to you twice asking for records related to this decision. Both times you refused. I'll ask again. Will you send the committee all records documenting this decision so we can review this in a bipartisan fashion? Mr. Secretary, this whole settlement, in my view, is the most brazen abuse of power ever in our history. And as of now, every American is subject to audit except Donald Trump and his family. I think that's absurd. And
every American is subject to audit except Donald Trump and his family. Senator Ron Wyden used those words to confront Scott Bessent over Trump's IRS settlement, demanding to know who canceled the audits, who authorized the deal, and why Congress still wasn't getting the answers.
So my first question is, does the IRS audit immunity given to Trump, his family, and his businesses still stand? I'd like a yes or no answer to that.
You can answer the question. You can't tell me how to answer it. So,
I got five minutes. I'm going to use them for these questions.
You're using up your time now, sir. As I said, I am unable to comment with ongoing litigation.
Okay. So that we understand what's at stake here, this immunity deal is the biggest scam against the taxpayer in American history. And Americans are going to pay taxes, and Trump and his clan won't. So we'll start with that. Now, my second question is, every president's tax return gets audited, Mr. Secretary. Who originated the May 19th addendum canceling Trump's audits? Was it Trump, DOJ, or Treasury?
Again, sir, as Albert Einstein said, doing the same thing and expecting a different answer is the definition of insanity.
You've given no answers on this subject, and that's why I'm going to ask these questions.
And because, as I said, there's ongoing litigation.
Does the DOJ have the authority to settle a tax dispute unilaterally?
The DOJ acts as the attorney for Treasury and the IRS.
So the tax code says the DOJ can only settle a tax dispute if you, the Treasury Secretary, first deferred the dispute to DOJ in the case we're talking about. So here, Trump, his kids, all of the business entities they own, potentially thousands of tax returns, and unless you referred every single one of those tax returns to DOJ, the addendum is invalid, or the Treasury and the IRS believe have been more involved in this scandal, as far as I can tell, than you've led us to believe. So I'm going to keep digging into the timetable here. Career IRS attorneys wrote a 25-page memo preparing defenses against Trump's lawsuit, and they recommended DOJ move to have Trump's lawsuit dismissed. The IRS reportedly gave this memo to Treasury officials in April before the settlement. Did you see that memo?
There's continuing litigation, and I'm unable to answer.
Will you provide this committee with a copy of the IRS memo?
On July 13th, a federal judge barred Trump from using his IRS lawsuit and the settlement to claim extraordinary amnesty from investigations into his tax returns, his family's returns, and associated businesses. Senator Wyden immediately called the ruling a rejection of what he described as a sweetheart audit immunity deal. So the question Wyden pressed here, whether the settlement could stop scrutiny of Trump's past tax returns, ultimately became the subject of a federal court ruling.
Again, there's continuing litigation.
Mr. Chairman, I'm going to continue my questions, but I would like to ask you now to authorize the 6103 waiver and for Mr. Bessent to waive the attorney-client privilege, which I guess is part of what he's up to.
I will not. I'm not quite sure what you're asking, but I will not agree to ask him to waive his attorney-client privilege.
It's the way we're going to get to the bottom of it, is to have the committee look at these matters in a bipartisan way, and I'm just going to continue with the questions that highlight My argument, the Biden administration prosecuted Charles Littlejohn, the Booz Allen contractor who leaked Trump's tax returns. Booz Allen, which helped with the prosecution, held contracts with the Treasury Department for years. 3 days before Trump filed his lawsuit this year, you abruptly canceled all the contracts. It is hard to see that timing be a coincidence. Did you know in advance that Trump was going to file a suit against the IRS?
I did not.
All right, I've written to you twice asking for records related to this decision. Both times you refused. I'll ask again. Will you send the committee all records documenting this decision so we can review this in a bipartisan fashion?
Again, there is ongoing litigation, and Senator, how we got here was a violation of President Trump's 6103 rights. And it wasn't just President Trump. There were 400,000 tax returns that were leaked by Mr. Littlejohn. And I will point out that Mr. Littlejohn was not prosecuted to the fullest extent of the law. He was eligible to be prosecuted on 3 counts. The Biden administration chose light touch and only prosecuted him on 2 counts.
We're going to continue these questions, and I come back to my point, Mr. Chairman. We need you to support this 6103 waiver so that this committee on a bipartisan basis can look into a matter like this. When you're talking about the President of the United States, it doesn't get any more important. And I'll just close my opening effort to try to ferret out the facts here, Mr. Chairman, by saying, Mr. Secretary, this whole settlement, in my view, is the most brazen abuse of power ever in our history.
There was a major development involving the $1.8 billion fund after this hearing. On August 2nd, Acting Attorney General Todd Blanche formally rescinded the Anti-Weaponization Fund, stating that it had no force or effect and that no commissioners had been appointed, no money transferred, and no claims paid. That was a significant change from the settlement discussed here in June, because the proposed fund was one of the most controversial parts of the agreement.
And as of now, every American is subject to audit except Donald Trump and his family. I think that's absurd, and you've been dodging questions. Each one of these, you had a legal argument for saying nothing. And I suspect you cleared the way for Trump's lawsuit when you canceled the contracts, and I suspect people right up to the highest level of the Treasury Department had a hand in crafting this unbelievably corrupt gift of a settlement. And I just want it understood, colleagues, I want to work with every senator on this committee to get to the bottom of this, because we aren't getting the facts. And the Secretary, in spite of the fact that he owes answers to the American people, is just dodging and bobbing and weaving. Thank you.
On July 13th, a federal judge delivered a major development directly relevant to the confrontation between Ron Wyden and Treasury Secretary Scott Bessent. The court barred Donald Trump from using his lawsuit against the IRS and the resulting settlement as a basis for claiming extraordinary immunity from investigations into his tax returns. Wyden immediately argued that the ruling confirmed the seriousness of the concerns he had raised. This was significant because at the June 3rd hearing, Bessent repeatedly declined to say whether Trump and his family remain protected from IRS audits, citing ongoing litigation. The controversy did not end with that ruling. On August 6th, Wyden and House Ways and Means Ranking Member Richard Neal introduced legislation specifically designed to rescind the Trump audit immunity arrangement, arguing that Congress needs an enforceable check on the executive branch rather than relying on administrative assurances. The legislation followed a Senate Finance Committee markup in which Democratic members backed Wyden's effort to block the deal. The continuing congressional push is important because it shows that the questions Wyden raised in June have evolved from a contentious hearing exchange into an ongoing fight over the limits of executive power, IRS independence, and congressional oversight. The confrontation itself centered on an extraordinary situation. Trump had sued the Treasury Department and IRS over the disclosure of his tax information, while the administration he controlled was simultaneously responsible for resolving that dispute. The settlement announced in May became especially controversial after a one-page addendum signed by Acting Attorney General Todd Blanche stated that the IRS would be barred from pursuing past examinations involving Trump, members of his family, and associated businesses. Reuters reported that the language extended to matters that had already been raised or could have been raised before the settlement. That is why Wyden was not simply asking Bessent about an ordinary tax case. He was questioning whether the government had effectively created a special exemption for the president. Wyden's strategy was to force Bessent into a yes or no answer at the very beginning. His first question was whether the alleged audit immunity still existed after the administration abandoned the separate compensation fund. But Bessent repeatedly relied on the existence of ongoing litigation to avoid answering. That response gave Bessent a legally cautious position, but it also created the exact political problem Wyden was trying to expose. The Treasury Secretary oversees the IRS, yet the committee was unable to get a straightforward explanation of whether the president was still protected from audits. There is a legitimate argument on Bessent's side. When litigation is active, administration officials have to be careful not to make statements that could affect the government's position in court. Bessent was not necessarily obligated to publicly disclose privileged legal advice or discuss litigation strategy simply because a senator demanded a yes or no answer. His repeated refusal, therefore, cannot automatically be treated as proof that he personally approved the disputed arrangement. The hearing transcript shows him invoking ongoing litigation rather than affirmatively confirming the substance of Wyden's allegations. But Wyden's counterargument was about congressional oversight. He was not merely asking Bessent to reveal litigation strategy. He wanted to know who authorized the May 19th addendum, how the Treasury and IRS became involved, whether Treasury had referred the relevant disputes to the Justice Department, and whether career IRS lawyers had advised against the settlement. Wyden also pointed to a reported IRS legal memorandum that had recommended defending against Trump's lawsuit rather than settling it. The Senate Finance Committee later formally demanded records and communications concerning the agreement, including material involving Treasury, the IRS, and the White House. That makes the question about procedure particularly important. Wyden's argument was essentially that the government cannot simply bypass the normal structure for resolving tax disputes because the taxpayer happens to be the president. He raised the statutory framework governing DOJ's role in tax litigation and questioned whether the necessary Treasury referral had occurred. If his interpretation is correct, the issue would not merely be whether the settlement was politically controversial. It could become a question about whether the government followed the legal process required to make such a settlement valid. Bessent's strongest defense was that the situation involved litigation and that Trump's tax information had been unlawfully disclosed in the first place. During the hearing, he emphasized the scale of the underlying breach, pointing to approximately 400,000 tax returns that were leaked by former IRS contractor Charles Littlejohn. He also criticized the Biden administration's prosecution of Littlejohn, arguing that prosecutors had chosen a less severe path than was legally available. That shifted the conversation toward an issue where Bessent had a stronger factual and political argument. Protecting taxpayer confidentiality is a fundamental responsibility of the IRS, regardless of whose returns were compromised. Wyden, however, was deliberately separating those two issues. Nobody in the exchange disputed that leaking confidential tax returns was serious. His concern was what happened after the leak. His argument was that punishing or compensating a victim of unlawful disclosure does not automatically justify permanently preventing the IRS from examining unrelated potential tax liabilities. That distinction is central to understanding why the hearing became so heated. The confrontation also raised a broader institutional question. If the president can sue a federal agency, then negotiate a settlement with officials appointed by that same president and obtain language restricting future government action against him or his businesses, where does normal accountability begin and end? Critics argued that the arrangement could create an unacceptable precedent. The administration, meanwhile, could argue that the settlement was designed to resolve litigation arising from a genuine violation of Trump's taxpayer rights, and that the legality of the arrangement ultimately belongs in court rather than being decided through a Senate hearing. The subsequent federal ruling substantially changed the context. The judge's July decision prevented Trump from treating the settlement as a blanket shield against tax investigations, directly weakening the practical effect of the immunity language that had triggered Wyden's questioning. And by August, Wyden was still pursuing legislative action to eliminate the arrangement altogether. So while the June hearing ended without Bessent providing the answers Wyden demanded, the controversy did not disappear. It moved into the courts and Congress. What made this confrontation so powerful was that neither side was really arguing about the same thing. Wyden was demanding transparency over whether presidential power had been used to obtain extraordinary tax protection, while Bessent emphasized litigation constraints and the government's obligation to protect Trump's unlawfully disclosed tax information. The later court ruling gives Wyden's oversight concerns greater weight, but does not by itself establish every accusation he made during the hearing. Was Wyden right to treat the settlement as a potential abuse of presidential power, or was Bessent justified in refusing to discuss a matter still before the courts? And should Congress ultimately have the power to overturn an executive branch settlement of this kind? Tell us what you think in the comments, and subscribe to Capitol Clips for more congressional confrontations, verified developments, and analysis of the issues behind the headlines.